So we're going to be looking at, to start with, the breach of the rental covenant. And the reason I'm doing that is because I think in today's world, particularly with the economy not quite as booming as it might otherwise be, more landlords are concerned about their rental income stream. And so for many landlords, and I would suggest probably the majority of commercial landlords, the impact of the tenant's failure to pay rent is going to be of greatest importance to the landlord. And it's going to be the breach of covenant that they're going to want to sort of knock on the head as soon as possible. For sure, other breaches of covenant will be or may be important, but the failure to pay rent, and indeed sums generally due under the lease, I think is probably going to be the one that most landlords will concentrate on because it's going to affect their bottom line. If you forfeited by court proceedings, then as you can see, the tenant is entitled to automatic relief from forfeiture on payment of the arrears before the hearing. And then there's a discretion given to the court for up to 6 months after execution of the possession order. So that's quite a long time when you think about it, because you've issued proceedings, now you've got a court order, then you've executed the court order. Discretionary relief for up to 6 months after execution of the possession in the county court. And in the High Court, which is very, very rare indeed, it depends very much on the arrears level and the payment time. This is under the Common Law Procedure Act 1852, but it's fairly similar to the county court. So I think something like we're required to remedy the breach insofar as it is capable of remedy sidesteps all of that remediable, irremediable breach problem. And then you have to give the tenant sufficient time to remedy the breach if it's capable of being remedied. So you can't take any steps until a reasonable time has elapsed. And how long is that? How long is a piece of string? It depends on the breach of covenant. I would always allow, even for irremediable breaches, 2 weeks minimum between serving the notice and taking the next step. If there's any concern about it, take advice from a surveyor or a valuer as to how long this is going to take to sort out.